So it's nice to be here in person. Before I call this morning's argued cases, I'd like to take a few minutes to introduce the members of our distinguished panel. To my right, your left, we have Judge Stephen Hill, who has served on our court since 2003, and before that served as a district judge in Paola. And as of this year, Judge Hill is the longest serving judge in the state of Kansas. And then to my left and your right is Judge Karen Arnold Berger of the Court of Appeals, who joined our court in 2011 and has just completed 8 years as chief judge of our court. And before joining the appellate bench, she presided over the municipal court in Overland Park for many, many years. And I'm Sarah Warner. I have served on the court since 2019. I grew up in Pittsburgh and now live in Lenexa, had a private practice in Lawrence before joining the bench. And since about 2 weeks ago, I have served as chief judge of our court. Now, that just means that I'll be presiding over this morning's arguments. In preparation for today, we have thoroughly reviewed the parties' briefs and the court record, along with legal memoranda prepared by research attorneys. So we are very familiar with the facts, and we encourage the parties to dive directly into the legal arguments that are presented. We will be hearing arguments in 2 cases that are related this morning. The first case has been scheduled for 15 minutes of arguments on each side, and the second case has been scheduled for 20 minutes of arguments. I will be keeping time, but I will be doing so in a fairly flexible manner because the bottom line is I want to make sure that my colleagues and I have the opportunity to ask whatever questions we need to be able to decide these 2 cases. Before we jump into arguments, I do have one house cleaning matter that I wanted to cover, and that is these 2 appeals arose from a single case at the district court level, and they were appealed separately, briefed separately. Our court denied a request for consolidation earlier in the case after the briefing had occurred. And that means that we are going to have some duplicative argument. But I did want to make sure that the state appellants will be the only ones arguing as appellants in the first case. Is that correct?
That is correct, Your Honor.
All right. And thank you very much. And then the intervener appellants will be arguing in the second case?
Yes, Your Honor.
Thank you. And of course, the state, same counsel on both cases. Is that?
Afraid you're stuck with me.
Thank you. Thank you very much. With that, we can turn to the cases that are before us. The first case on this morning's docket is case number 127522 from Shawnee County, State of Kansas, ex-rel Chris Kobach, Attorney General, Applee versus David Harper, Director of Vehicles in his official capacity, and Mark Burkhart, Secretary of Revenue, in his official capacity, appellants. Would the parties please state their appearances?
May it please the court, Your Honor. Counsel, the appellants appear by Nicole Revenue, Mr. Ted Smith, counsel for the Department of Revenue. My name is Pedro Riganagaray. I am retained counsel for the department.
Thank you.
May it please the court, Solicitor General Anthony Powell appearing on behalf of the state, and with me at council table is Assistant Solicitor General Ryan Ott.
Thank you very much. Counsel, would you like any time for rebuttal?
I would, Your Honor. If I would be granted 5 minutes, I would appreciate it.
5 minutes are granted. And thank you. Counsel, you may begin.
May it please the court, counsel. It is our position that Senate Bill 180 does not apply to Kansas driver's licenses. Senate Bill 180 was passed in 2023. Shortly thereafter, Attorney General Chris Kobach filed an opinion based on a request by a representative asking for an opinion regarding the applicability of Senate Bill 180 to driver's licenses. And in his opinion, that Senate Bill 180 did apply, and as a consequence, required the Department of Revenue to issue driver's licenses in a manner in which they had not done for about 17 years, which is instead of using the gender as an identifier in the statutes, it required that the sex assigned at birth be placed on the driver's license. Now, notwithstanding the fact that the driver's license itself uses the term sex, that's as a consequence of the state of Kansas being in conformity with the other 50 states in the manner that those licenses are uniformly used. The difficulty that arose is that the state, through the Department of Revenue, disagreed with the Attorney General's interpretation. And Governor Kelly vetoed that Senate Bill 180. The bill was,
Did the interpretation come out before the veto?
say that again?
Did Attorney General Kobach's interpretation of the statute come out before the veto or after the veto? I thought it was perhaps after the veto.
It was after the veto.
Okay, thank you.
And the issue then becomes whether or not the Senate Bill 180's wording is applicable. In order to conclude that the legislature in 2023 was unaware of the difference between sex and gender, one would have to believe that the state legislature was operating on a 15th century mentality. Gender and sex have been known since the 1950s to mean completely different things. Sex is a biological issue that can be recognized scientifically by the genitalia, gonads, etc. Gender is an issue of expression, is how one feels as a human being. Unfortunately, the Attorney General's opinion and the position that the Attorney General's office has taken would require this court to legislatively conclude that the state has a right to make individuals that are transgender invisible, that they don't exist.
Counsel, I'd like to talk about the state's position. And I understand that we have two state parties, and so it's difficult to track the state's position. But I understand that the driver's license statutes use the word gender, but the driver's license itself uses the word sex. Could you explain that difference?
Yes, the driver's license is a format issue. It's the statute that governs, and the statute uses the term gender. That term has been in place since 2009, following the Real ID Act and Senate Bill 9 that modified that process.
Well, Counsel, is it your view then that that little card that we all carry that says sex is not a record? The record is in the computers of the Department of Revenue.
That is,
That's the gender, record that you're talking about, and this is just simply labeled that all driver's licenses use. Is that?
That is correct, Your Honor. And that is,
And what is the significance of that in terms of this case in this particular appeal?
well, the significance is that the legislature had a choice in what words they use. And instead of using in Senate Bill 180, the term gender in conjunction with sex, they simply used the term sex and avoided any reference to gender. So therefore, the statute is unambiguous on its face. It applies to sex. Our statutes regarding driver's licenses use the term gender, and therefore it is not applicable.
So how did the district court then err?
The district court erred in a number of ways. First of all, by concluding that Senate Bill 180 did apply because it assumed or concluded that the terms gender and sex are synonymous, when in fact they are not. It would require willful ignorance for the proposition that they are synonymous as of 2023 when Senate Bill 180 was passed. Additionally, the court erred by finding in issuing its temporary injunction that the state had proven irreparable harm. The Attorney General raised two issues for irreparable harm. One, fleeing criminals, alleging that unless driver's licenses appropriately demonstrated sex assigned at birth, we were going to have transgender people avoiding justice, escaping. There wasn't a single, not one iota of evidence to support that allegation.
Well, there was one iota, right?
Well, but that was not a fleeing criminal. That was an individual, Your Honor, that was arrested and appropriately identified at the Shawnee County Jail, which is not the same as the scare tactic used by the Attorney General that fleeing transgenders were going to be everywhere because they were going to avoid the arms of justice through the legal, through law enforcement.
Am I right, counsel, that I think I read somewhere in the record that there were 9 million driver's licenses issued and only 350 or so dealt with this gender issue?
That is absolutely correct, Your Honor. And in fact, what I did is I then decided or determined what the percentage of transgender driver's licenses were, and it comes out to 0.004%. So we're talking about a minute population. The second area of irreparable harm that the Attorney General claimed was organ transplant. And in support of that position, the Attorney General of Kansas misled the court, again, by unnecessarily attacking transgender people. The Attorney General claimed.
Haven't they abandoned that argument, though?
Well, they have abandoned that argument, Your Honor, but nonetheless, it caused harm by proclaiming that organ transplants without the appropriate marker on the driver's license were going to result in botched organ transplants.
Okay, so if they've abandoned that, though, that's not one of the issues they're now arguing results in irreparable harm, correct? So what are we to do with that?
Well, I was asked
Right,
how the court erred,
right.
and my point, the point I want to make, Your Honor, is that in support of that argument, the Attorney General provided the court with a Harvard Gazette article in support of the botched organ transplants, when in fact, Your Honor, the last paragraph in that article states, transplant rejection is a complicated phenomenon with many contributing factors. And the researchers note that mismatched sex of a donor should not be a cause for concern for transplant recipients. The opposite of what the Attorney General was claiming that article said. So the court erred in those two forms.
Okay,
And
and I
you are
have,
asking us to simply reverse it and remand for,
Well,
Trial?
I suggest that the court should do more than that. First, there was no evidence of irreparable harm, and as the court is well aware, the 5 elements must be all met. Irreparable harm was not established. But more basically, the court can do away with this entire case by concluding that Senate Bill 180 is inapplicable to the Department of Revenue's driver's licenses because it's unambiguous, it does not address gender, it addresses sex.
I have a question. And this kind of goes back to the very beginning. So the Attorney General, after the veto, is requested by a legislator who is apparently confused as to whether or not this applies to several situations, driver's license included, and the Attorney General issues an opinion. I'm assuming that DMV also has attorneys, and they must have, or we wouldn't be here, concluded that this did not apply. So my question is, do we owe any special deference to the Attorney General opinion versus whatever legal opinion the DMV may have come up with internally? Does the Attorney General's opinion as to the application of this statute, should we give deference to that, or does the law require we give deference to that?
I don't believe it does, Your Honor. It is an opinion, it's a formal opinion, and it came about as a result of a legislator questioning whether or not it did apply. So no, I don't think the opinion should be any greater than the opinion.
Because as Chief Judge Warner alluded to, this is a very strange case. We have to say the state's position is this, we can't, because we have 2 state entities that are battling it out as to how this law applies. So I just wanted to
Yeah, I don't.
see if you feel we need to give we should be giving deference to one opinion over the other. They're both state opinions.
With
Correct?
all respect to that office, I don't believe that it deserves any more deference than the opinion from the Department of Revenue. And in the final analysis, we have to consider in today's world what those 2 words mean, gender versus sex.
Counsel, in looking at, I believe you called the use of sex on the driver's license a formatting issue. Is there anything to stop the Department of Revenue from changing that format, from placing gender instead of sex on the driver's license card?
Only in the fact, Your Honor, that it would then differ from the other 50 states. And there's a benefit to having that type of uniformity. But again, the statutes, the Kansas statutes that address driver's license use the term gender. This is just a formatting issue, not law.
Can you talk to me a little bit about the database that the Department of Revenue maintains and how that comes about? Is the information in that database inputted when someone applies for a driver's license and then maintained, or does it come from elsewhere?
No, it is maintained. It's not, the Department of Revenue is not Vital Statistics. That's a completely different agency, but it does retain those records. And whenever there is a change, the department does maintain the previous history. So that's contained by the department or retained by the department.
Is there anything in the record about the process for when someone who was born out of state comes into Kansas and applies for a Kansas driver's license.
And that's another issue that presents difficulties if we change the designation from gender to sex. A number of states, in fact, most states, 48, allow the change of gender process. They recognize that in today's world, that is a medical issue. So if a resident of a foreign state that has a previously issued gender appropriate driver's license comes into the state of Kansas accepts that driver's license, if I understand the question, Your Honor. And therefore, the state has no way to ascertain whether or not historically that driver's license with the gender marker that it shows is as a consequence of a previously modified gender appropriate designation.
Is there anything in the record about the process, if someone were to come in and apply for a driver's license with a birth certificate from out of state that had been amended? Is there anything in the record about the process that the department uses in those circumstances?
I don't recall how specific that record is, but I can tell you that that would be one of the criteria that would be needed in order to issue a Kansas driver's license. In addition, there are other requirements, like one cannot retain driver's licenses from multiple states, et cetera. But the foreign birth certificate is certainly an acceptable presentation of identity to the Department of Motor Revenue.
And if we could go,
No.
if we could go back to the database, if I previously was unmarried and got married and changed my name, would the database include my previous name, assuming I had a Kansas driver's license under that name, and then the changed name when I had a?
I believe it would, Your Honor.
Thank you.
I believe my time is.
Council, I believe your time is up. Are there any other questions from the panel? All right, thank you
Thank you very much.
We asked you some questions, so I will make sure that you get your 5 minutes for
Thank you.
rebuttal. And council, because we went a little long, you have all morning.
No.
Thank you very much. May it please the court. Contrary to with all the press attendance, you might think that this is really something that it's other than what it really is. It's a mere statutory interpretation case. Now it's clouded with the issues of transgenderism, but really what this case boils down to is, did the legislature in 2007, when it revised the driver's license statute to conform with the Real ID Act, did the legislature at that time mean that gender meant something different than sex? I submit to you that common sense says no. And now Mr. Iraganagaray would say that we somehow knew about gender identity issues from the 50s. And maybe among the experts that might be true, but I would suggest, at least in my own circumstances, is I've been only aware of the differences in that over the past few years. I submit that that's a relatively recent phenomena.
So
I think
counsel, are you suggesting that what we're looking at the statutory interpretation of the 2007 revised driver's license statute? Because I thought we were looking at the interpretation of the 2023 Senate Bill 180.
Well, I'm getting to that, and I'll
Okay.
explain to you why. Because I do think this issue comes down to gender versus sex. Are they synonymous?
Right.
And at that time, gender and sex weren't specifically defined, but they were meant the same thing.
But certainly in 2023,
And-
we may not have known in the 50s, but by 2023, the legislature and anybody would have understood that there were issues related to the term gender and the term sex. Right?
Some might have. I don't know if all those, and I'm not prepared to concede that notion because I
Okay.
think the statute and the legislative history doesn't really address that per se. I know one of the proponents of the bill talks about that issue, but I think talking about legislators and what their views about that, I don't think that that's clear at all. I think what the legislature was doing was responding particularly to the issue of biological men competing against women in sports. That was the real impetus for Senate Bill 180. And what they wanted to do,
So
I think,
perhaps they didn't even realize there was the problem with gender being listed in the driver's license statute? Is that what you're
maybe,
saying?
I don't think we really know for sure.
And
I
does
think
the-
that it's conceivable they didn't want to get into the weeds of all of that. And maybe they didn't think that, there really was a difference, so they didn't see the issue. I think though,
Well, what do we have to work with? All we have are the statutes, correct?
right,
The rest of this isn't our function here to interpret these two statutes?
Judge. And I,
Which is exactly what the district court attempted to do. And so you have to show us some irreparable harm. You did, and now show it to me.
okay, here's a few things. You don't have to take my word for it. Let me point to some things for you.
That's right.
First of all, we cited in our brief two dictionary definitions of gender.
Mhm.
And those conform to what the legislature has said sex means in essence. That gender really means sex. It's something, as it's used in the statute, it's something different than gender identity. Gender identity is different from what the legislature and the statutes are talking about when it comes to gender and sex in this context. So you've got that. Second, and we cited these statutes in our brief, there's a number of statutes that use gender and sex interchangeably. KSA 77-201 talks about in statutory interpretation, the words in masculine gender are also only extended to females. KSA 65-6710A3, gender is determined at fertilization. A newly fertilized egg cannot determine the inner sense of their particular being. So clearly, gender in that statute isn't meaning gender identity and what you feel in your heart you really are, but is a physical property. Third, the abortion statute uses gender, meaning you can't use, sex-based abortion. So there's a history here of the legislature using gender and sex interchangeably.
So your argument is then that we should adopt that view and because that's how they've dealt with it in the past.
Yes.
Does it matter though, council, that the legislature didn't do that here in 77, and what is now KSA
I
77-207?
don't believe so, no.
Just to use the word sex?
I don't believe so, no, I don't. And I will tell you that if you look at, you don't even have to take my word for it. We've cited in our brief, the Indiana Court of Appeals took up this very same issue. And they said, when they there were transgender individuals, they wanted to have their license be declared as non-binary in their driver's license. And the Indiana Court of Appeals said, in this context, the legislature never showed that there's a difference between gender and sex, and that it's a biological distinction and it's binary. And so they basically rejected that argument. And I think you can follow their reasoning and you don't have to trod this path for the first time yourselves. You can see another court and they've done something very similar.
Well, counsel, we always, when we're talking about legislation and interpreting legislation, talk about the fact that words matter. And the legislators are faced with hundreds of pieces of legislation each year to go through and try to decide what language they're going to use. And they have entire staffs to help them with this, right? Staffs that if there are places where sex is used and gender is used would have the responsibility of notifying the legislature that we've got some issues here and recommending particular language. Correct? Isn't that what the staff does?
Well, Judge, as you and I know very well, and I certainly recall from my experience in the legislature, if it were only that, learned and scientific, but it's just not. And it's hard to know for sure. I know the court routinely grapples with statutes that are sometimes confusing. You're trying to piece it together, and that's proof that the legislative process can be kind of ugly, can be a little messy. And I suggest that in this case, they didn't think the legislature didn't consider every angle, and I think they were trying to take the most straightforward approach. I think it's clear they wanted clarity in the statute. They want consistency in the statute, and that was the emphatic approach that they wanted to take.
And what should we draw from the fact that the notes that were accompanied Senate Bill 180 when it was passed? Let me see if I can find those, the reviser's notes or whatever they were, listed this bill would apply to, and listed several things it would apply to, generally related to sports and the things you've mentioned. And listed there was never driver's licenses. What should we make from that?
I wouldn't make anything from it because I don't think the revisor says what's applicable or not. And that gets to I just thought of it since you asked the question. First of all, it's the Attorney General that represents the state in this litigation. The respondents is a one state agency and specifically two individuals, officials of a state agency. So it's this office that speaks for the state, not the Department of Revenue or its officials. So I think that's important.
So
you're not entitled.
We should give,
No, we're
deference.
not entitled to give our opinions any deference. I'd like to think that our reasoning is persuasive, but that's obviously for you to judge. But we speak for the state, and I think it's important that the Constitution and the statutes of our state give us that authority to speak for the state.
But from time to time, there's a disagreement and you turn to the courts to resolve it. Is this a political question?
No,
Why?
this is, it's an uncomfortable position to be in where you have to sue a state agency to get them to comply with the law. And that's what we had to do here. And doesn't happen very often. Usually we're on the other side of this fence defending a state action and saying, yes, in fact, they did abide by the law. And of course, we sometimes lose those. It's pretty rare for us to have to go to court to tell an agency, you need to follow the law. But that was our duty, and that's what we're doing in this case. And the district court agreed with us with regard to the interpretation.
For my benefit, I tell me as distinctly as possible what irreparable harm you proved in district court. Because I think that's the focus of, at least in this first appeal.
Three things, Judge.
Irreparable harm. Thank you.
First, and we emphasize this all along, it's irreparable harm for a state agency to not obey the law. That's a grievous violation. It's intolerable, and it's the duty of a state agency to follow the law. That's our biggest irreparable harm.
And is
That's
the
our
harm
position.
that they failed to follow the law or that they disagree with your interpretation of the law?
They failed to follow it.
Okay.
They failed to follow it. Second, it's the law enforcement harms that were just testified to in the hearing. The one particular incident that Sheriff Hill testified to, where there was an individual who, because of their transgender status and the dichotomy on the license, they didn't know that person's criminal history until they found out the biological sex of that individual. So there's very real harm.
And what was the harm of that? What harm ended up from that?
Because they didn't know what type this person had a long criminal record. They didn't know that. So imagine you're a police officer.
How would they have done it differently? I mean, they arrested the person and they sent him to jail and it was determined what their real sex
Right,
was.
but
What harm resulted from
There
that?
are risks. I mean, law enforcement's out there on the street. They're encountering unknown individuals. The whole purpose of the identity check is you want to learn who is this person who they claim to be. And they do, background check, quick background checks to say, is this person violent? That particular situation impeded their ability to know what type of criminal history this person had and did this person have a propensity for violence or not. I submit that that's pretty darn important. And I think that's whatever benefit might
What
go
about
to
all the other
individuals.
law enforcement agencies that presented evidence that there was no impact? They
Well-
hadn't noticed any issues with transgender people and driver's
Well,
licenses.
there aren't that many transgender people out there.
Exactly.
That's part of the issue, but I don't think numbers is a pure stake, and I don't think that that's necessarily true. The sheriff who supervises the Johnson County Jail talked about issues with regard to placement
Mhm.
in the jail, about which officer you're going to use, whether you're going to use a male officer or a female officer to frisk a particular inmate. Those are important considerations as well.
And at least for according to your opposing counsel, for the last 17 years, this has been the status quo. And has there been a great outrage from law enforcement all over the state in the last 17 years that this gender issue has been a safety problem?
Well, I can't speak to that. That wasn't presented in the hearing, but certainly now that the issues come up, law enforcement did come to us and it did express a concern, and we, picked a couple of examples to present to the court. I mean, we were sort of under a short time frame. The other harm is that a driver's license can't be easily recalled. I mean, I'm not even sure how you would recall it. When you're issued a driver's license, it's for 6 years.
Mhm.
And so if the Department of Revenue is out there issuing driver's license that don't accurately reflect a person's biological sex, then, that's out there in circulation. And there's really no way to recall that. That's also an irreparable harm for the state. So those are our three irreparable harms that we proved in court.
From a practical matter, counsel, how, going back to my questions to your opposing counsel about if someone comes in from out of state and we don't have the record, or I'm assuming we're giving full faith and credit to the record that existed from that other state. And so how do we resolve that in light of this new bill?
Okay, couple of things I'd say about that. First, we didn't talk about, I don't believe we talked about it in our brief, but we had a companion birth certificate case in federal court. And the federal judge, because of Senate Bill 180, reversed the Department of Health and Environment's prior policy where they were allowing changes, and agreed with us that you have to put biological sex on birth certificates. So in terms of getting a license, if you're a Kansan today, when you have to present your birth certificate, that's going to reflect that individual's biological sex at birth, which is consistent with the statute, and that's not going to be a problem.
But if they were
The issue
born
is-
out of state?
The issue is someone from out of state, and I think the practice has been is they take the birth certificate at face value. Under the statute, that practice may have to change. I can't really speak for the department about that, but it seems to me that since our record, they keep a record of those changes, both in the driver's license and in birth certificate. It seems to me there's probably a way for, let's say you have someone from Ohio who wants to get a license in Kansas and they had their, sex changed on their birth certificate from Ohio, that there would be a way to obtain the prior historical record of their birth certificate to reflect what their biological sex was at birth. But again, that evidence really isn't in the record. The department could speak to that better than I can, but that's my understanding.
Counsel, you mentioned that this is a simple issue of statutory construction, and I would agree with that. But it's also, we are not here to determine ultimately whether or not what the interpretation of the statute is. All we're here is to determine under our standard for temporary or for preliminary injunctions is, do you have are you likely to succeed on this? Even if we would determine that you are likely to succeed, that doesn't mean it's going to have to go back to the district court for an actual determination on the legal issues involved, correct?
True.
So we can't lose sight of the fact that this is an injunction action.
Right.
And injunction actions are termed extraordinary remedies. Our court system, we believe that people should have a right to have their day in court and weigh the different and not have some prejudgment made about their case, which is what an injunction does, basically. Correct?
Yes.
So, as a, now I've of course lost my train of thought as to what my point was, but the status quo, generally our laws assume that you're going to keep the status quo pending litigation. And it goes back to my point of there's been 17 years of status quo. What's the urgency that should require that a court intervene and say, whoa, stop, we're going to let the state's interpretation rule before we've had a whole hearing on this issue? What's the urgency here?
Well, Senate Bill 180 is what changed the formula here. And it's Senate
Right.
Bill 180 that has set the new reality here.
Right.
And I think, I mean, let's remember that this law was passed over the governor's veto. So you're talking 2/3 majorities in both houses of the legislature. So we're talking overwhelming support for this law. And it's an emphatic view expressed by the legislature that sex means biological sex at birth. And it was designed, I think, principally to protect women in sports, among other things. And that's the sea change. And with that, our view is to allow the agency, which was operating under a different rubric before Senate Bill 180 was passed. In fact, I'm curious as to wonder how many people really knew that was going on. But that changes the whole landscape of this. And I don't think the public.
So are you saying that whenever there's a statute passed that has a supermajority of legislators, then we really shouldn't pay any attention as to what another party on the other side of the case may view as an improper legislative authority or whatever? We should give full deference to the legislature to issue an injunction in those situations. I mean, is it based on how much support the legislation had, or?
No, I think what the real argument here is we have a clear and unambiguous statement from the legislature through Senate Bill 180 that this is how you define man and a woman. This is how you define sex, and that's synonymous with gender, and it's a clear directive, it's unambiguous, and that the Department of Revenue has the obligation to follow it. That's the crux of the issue here.
I agree, that's the issue. My point
And
is,
for you,
what's
for this
the issue for a temporary?
this court to not uphold the district court's injunction, which is this, abuse of discretion standard,
Use of discretion.
is to say, we're going to allow the lawlessness to continue. And I think that's wrong.
And what
we've-
lawlessness has
we-
happened in 17 years?
Well,
I mean, we're back to irreparable injury.
the
again.
lawlessness is when it became lawless when the legislature passed Senate Bill 180 is when it became
I get
lawless. But I would submit to you that even back when the department was allowing for changes, they weren't thinking about it in terms of gender identity. You look at their policy, I've got it right here. It talks about a doctor having to submit a letter in writing based upon physical criteria. So they weren't even thinking in terms of gender identity and how do I feel and what's my attitude about my deepest core of my being with regard to, am I representing, do I have some dysphoria about my sexual identity or gender identity? This is talking about physical criteria. We're talking medical, physical attributes here. And so I think that makes it different too. I'm not convinced when you look at this policy that's been in existence even prior to Senate Bill 180, that I think that they weren't thinking in terms of how the legislature necessarily defined sex. I think it was something other than gender identity.
Council, normally when we talk about statutory interpretation and whether a statute is ambiguous or unambiguous, we just look at the text. And if we look at the text of the bill in question here, the text is pretty clear, but I think the ambiguity arises in how does that statute communicate with the other statutes that are already in existence? For example, the Driver's License Act that uses the word gender. And that ambiguity seems to have been highlighted by the fact that you had a proponent of the bill who testified before the committee that the bill did not apply, was not intended to apply to driver's licenses. And you had an opponent of the bill saying that maybe this bill could apply to driver's licenses, and if you did, then it would run into these constitutional infirmities. I'm just trying to figure out what is the definition of ambiguity, or how do you see ambiguity in terms of the court's
Ambiguity, I
charge?
think the straight, well-known
Only,
definition is that
right?
it's susceptible of more than one interpretation. And our view in this context that it's not. And you look at the dictionary definitions, which, you know, what my understanding is when you're looking at an undefined term, what's your source that you go to first? Well, you go to a dictionary typically. I think that's pretty common. And we've cited to you two that essentially say the same thing, that gender is this binary physical concept of male and female.
Does that
So
does that
that's
analysis
also
become
sex.
altered if the same dictionary provides alternative definitions of gender?
No, I think those dictionaries talk about the problematic idea of trying to associate gender with gender identity, that it creates
And we're not talking
problems.
gender identity here. Isn't gender identity really a different term than gender?
But that's what the Department of Revenue and that's what interveners are talking about. They're the ones that are talking about gender identity.
Mhm.
The Attorney General and the state are saying gender and sex are the same. And that's the difference.
And so back to my question about ambiguity, do we limit our question as to whether a statute is ambiguous by looking at the four corners of that statute, or do we look beyond that statute?
I think you have to look at not only the four corners of the statute, but you have to look at it in its context. You have a duty to impar materia, make everything harmonious. You have a duty to do that. So I know you're all not strangers to any of those concepts. And that's what we're asking you to do here. We're asking you to harmonize it. And I think our position does harmonize those things, particularly when you, that's why I'm saying you have to go back and put yourself back in 2007 when the legislature went in, because it used to say sex in the driver's license and they changed it to gender. The other side wants to say there's big meaning to that, but we're saying no in the context of the time. And I would say up till now is most people see it gender and sex as synonymous. And I don't think that that's changed. Gender identity is a new concept, relatively new, at least in the minds of most people. And so that's how I think you look at it. See no more questions. I think I've probably gone way over, so I guess
Right.
I'll sit down if you have nothing
Thank you
further.
much.
Thank you. Thank you.
Council, I'm going to give you 6 minutes for rebuttal.
Thank you.
You're
Appreciate the generosity, Your Honor.
I'd like to hear your response, counsel, to the position that one of the harms is the mere fact that the DMV is going against legislation, that's an inherent harm, is the first harm, that you're not obeying the law. Would you respond to that?
Well, that argument is grounded on the proposition that the law is applicable.
Mhm.
The Department of Revenue's position is that that law is not applicable. Therefore, the department is not violating the law. If the legislature intended for Senate Bill 180 to apply to driver's licenses, they could have enumerated that, and they could have used the term gender to include driver's licenses. But to suggest that the Department of Revenue is in violation of the law, it's not accurate, because that law is not applicable to the Department of Revenue's issuance of driver's licenses. So therefore, that allegation of irreparable harm is non-existent, just like their claim of irreparable harm to law enforcement is non-existent. Thousands of arrests have been made by Sheriff Hill. Same thing with Mr. Newsom from Johnson County. Major Newsom asked all of his staff in Johnson County whether or not any of them had had any difficulties whatsoever. Not a single one. Counsel mentions that law enforcement came to them. Well, if that is the case, law enforcement had to provide them with specifics. The specifics that they alleged proved to be non-existent. So what did these law enforcement officers that came to the Attorney General's office, what did they present to the Attorney General as the irreparable harm? And if they did, why weren't those harms demonstrated on the record? I don't understand that discord. If law enforcement saw such a danger with transgender people that they felt the need, although not a single report was made to the Highway Patrol, to the Shawnee County Sheriff's Office, the Johnson County Sheriff's Office, or their detention center about transgender people, if in fact law enforcement came to the Attorney General's office, as has been stated by counsel, to proclaim the danger of transgender people if their ID is not indicative of their sex assigned at birth, why is it that we have not seen that evidence? Quite the contrary. Everything they presented has been debunked. As far as the
One other question. The driver's license change to comply with the Real ID Act. It's my understanding that that federal direction indicated that a state is able to define gender however it wants to define gender.
that is correct.
And there was no additional, there was no specific definition given to gender at that time. Is the elephant in the room, what's to prevent, the legislature's in session right now. They could go in and make that definition right now.
Absolutely. And they had that opportunity last year, and they chose not to.
So does that impact the finding of irreparable harm? Could the harm be irreparable if they could go in and change the legislation? It could have last session and could this session.
They could have done it with Senate Bill 180, and they chose not to. And it's also important, and I believe one of the judges raised the concern as far as legislators at the time Senate Bill 180 was being considered. During, and this is in our brief, during hearing testimony on March 6, 2023, Representative Ron Bryce, a Republican, asked witness Hadley Heath Manning, and he said, "You mentioned that there was a distinct difference between biological sex and gender, and I went back over the bill. The word gender is not in the bill." They knew. They knew the difference, and they chose not to include gender. The bill is unambiguous. the legislature chose not to include gender, I think that's the end of the process this court has to consider.
Council, I've let you run a little bit long and I want to make sure that my
Sorry.
colleagues don't have other questions, right? But so before you close, I want to make sure, are there other questions
No.
from the bench? Are there? All right, then I'll give you a few seconds to close up.
Thank you for the courtesy. We can talk all day about interpretation. We could do a review of what the level of review is by this court. But what I want to leave this court with is the following. It is not appropriate for a state to legislate discrimination. It is not appropriate for a state to deny transgender people the right to dignity. We know from our world's history what happens when a state diminishes the dignity of a class of human beings. We know where that train is headed, and it's headed to a place that we know is horrible. And what I ask this court is to consider, today is our transgender population, but who's next? Who are they going to target next? Today is transgender, our brothers, sisters, mothers, fathers, friends, neighbors. We must put a stop to this. State-sponsored discrimination has no place in our democracy. And this is what this bill is all about. It's discriminating against an innocent class of people. What is a transgender woman going to do when she goes?
Council.
I beg your pardon. I was
appreciate-
preaching. I understand.
Thank
Thank you.
Thank you.
Thank you
very
for your
much.
attention.
Thank you very much. And this court will take the matter under advisement. I understand that we have some choreography changes that need to happen. And so the court is going to take a 10-minute recess and we'll come back.